There's a significant weakness in your case. I address it with the jury during jury selection. I address it with the jury during opening arguments. I asked you about it when you get up to testify. But now, as the case gets to a close, as we go ahead and make closing arguments, is it okay if I don't mention it again? You don't want me to talk to the jury at all about this big weakness. I, on the other hand, say we have to do it. Who's right? What happens then? You want to know the answer? And importantly, what happens if I don't address it? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. And now the doctor refuses to acknowledge he did anything wrong. He says, "Don't blame me, I did everything right. Why are you suing me?" So now he fights this case tooth and nail throughout the entire litigation process. 2.5 years later, after you started your lawsuit, your case finally comes up for trial. And now we have a conversation before trial when I'm preparing you to get you ready for trial. I say, listen, we have a glaring weakness here. One of our experts is unable to fully support our claim that something was done wrong. And now he says, so what? Everybody else, all the other experts say we can go forward. Yes, that's true, but it's something we have to acknowledge. It's something we have to recognize and something we have to address. So now you go ahead and say, okay, so address it. So during the course of jury selection, when we are picking a jury, now I talk to the jurors about certain weaknesses in our case. I let them know that there are clear weaknesses. And can they still be open to the possibility that the doctor was careless and caused you harm? Yes, they can. They all agree that that can happen. And so they're open to that possibility. And now, during opening arguments, I go ahead and remind the jurors of this clear weakness. Now, that's obviously not the strong part of our case. I go ahead and focus on the strong part, but I do address the fact that there is a clear weakness in our case. I acknowledge it. I go ahead and confess to the jury that there is a clear weakness. And then I go ahead and try and explain it. And I say, listen, you're going to see all the testimony, you're going to hear the evidence that explains why that's an insignificant finding, that explains why this patient did the following things. So my goal is to acknowledge it, to recognize it, to tell the jury about it, not hide behind it, and then explain it away. That's my goal, and that's my intention. And now, when you get up to testify, I will be asking you questions about what happened to you. And part of that involves asking you questions about the weaknesses in our case. Hey, Mrs. Jones, why did you do that? Why didn't you go back to the doctor? Tell me why, if you had these problems, you didn't pick up the phone and schedule an appointment to go in. Or whatever the facts are, right? Because I want the witness, I want you, the injured patient, to acknowledge and accept the fact, yes, okay, there's a weakness here, there's a problem. Let me tell you about the problem, and then let me explain why we had these set of facts. That's the better practice. So now, as we get close to the end of your trial, let's say we're on trial for 2 weeks, and now we have a discussion in the hallway. I say, listen, we're now going to be making closing arguments, and I want you to know I have to bring up this weakness during the course of closing arguments. And you turn around and say to me, Mr. Oginski, you talked about that already. You talked about it in jury selection. You talked about it in opening arguments. Why do you keep beating on it over and over again? If you keep focusing on this weakness, the jury will think we have a terrible case. And you know what I say? I say, that's incorrect. I have an obligation to put our strongest foot forward, to put our best evidence forward, to show the jury that we do have a valid case, to build our case step by step, brick by brick, okay, with each piece of evidence. So now at the end of the case, they can reach the conclusion that yes, there were violations from the basic standards of care. And yes, those violations, that improper medical care, was a cause of your injury. So now, hopefully, the jury can reach that conclusion. And now I tell you, listen, if we fail to address that weakness, you know what's going to happen? The defense lawyer is going to focus on that entire weakness during most of his closing argument. And if I ignore it, you know what happens? Now it goes unanswered. Now the jury gets in their mind, okay, this weakness happens to be the biggest part of the defense for why you're not entitled to a verdict in your favor. And now the defense lawyer is certainly going to grasp that weakness and make it larger than life. He's going to use this to show to the jury that because of that weakness, you are not entitled to a verdict in your favor. And if we do not address it, now we're at a disadvantage. So now the jury will get the perception that this particular weakness, even though we don't think it's a big deal, that it's the biggest thing in the world. Why? That we're afraid to address it. And if we're afraid to address it, then clearly it has merit. And now we run into a problem. So even though you don't want to focus on it, and even though it may take up only 15 seconds of my closing argument, the fact remains, I need to address it. Because if I ignore it, the jury thinks, hey, we're hiding something, or we're hiding behind it, and I'm afraid to readdress it. And the moment that happens, now they give greater weight to the defense argument that this does constitute a significant problem for us. And now they begin to wonder, does Oginski and his client really have a valid case? What about this problem, this weakness that he mentioned, but now he's not saying anything? The moment I ignore it, then it blows up in our face. The better practice is I have to address it. And I'll address it, I'll slip it in the middle of two big arguments that I'm making. I'm arguing something where we have a lot of strength, and then I'll slip it in, showing that there's a weakness, and then I'll go back to making another strong argument. I just want to slip it in somewhere to let the jury know, hey, I haven't forgotten about this. Hey, by the way, you heard the defense lawyer talk about this weakness? Guess what? Sure, it's a weakness, but you know what? You know why this happened, and it's perfectly reasonable that this actually occurred. And in that instance, I go ahead and tell them the weakness, and then I explain it away, and then I get back to talking about our strengths. That's the better practice. So why do I share this quick information with you? I share it with you just to give you an inside look at what goes on in a medical malpractice case here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.